Dennis down bad. Here we go. Here we go. So, and it's coming through with a timestamp of 9:07 p.m. So this shows you their priorities, how quickly they'll get something done when it matters to them. So, state's motion to reconsider oral order striking witnesses' testimony and related exhibits. Comes now the state of Georgia and respectfully moves this honorable court to reconsider its October 17th, 2024 oral order striking the October 17th, 2024 testimony of witness, retired investigator, oh, that's a mouthful, T. Dennis, and related exhibits, and precluding his future testimony as a sanction for an inadvertent, non-responsive answer during his testimony. In support thereof, the state shows the following. Background. During Investigator Dennis's testimony, Investigator Dennis referred to actions Defendant Diamante Kendrick performed immediately after his release from custody. Defendant Kendrick moved for mistrial, which this court appropriately denied. As a sanction for this event, however, the court struck the entirety of Investigator Dennis's October 17th, 2024 testimony, precluded him from testifying in future, and struck from evidence exhibits which in Dennis, like, why do I gotta write it like that? Had authenticated on October 17th, 2024. 2. The scope of the state's claim. It is appropriate for the court to strike a witness's answer from the jury's consideration when it contains information the court finds the jury should not have heard and should not consider. The state does not contest that part of the court's ruling. The state submits, however, that the order striking the entirety of the witness's October 17th, 2024 testimony, precluding the witness from testifying in the future, and excluding exhibits which had been admitted through that witness on October 17th, 2024, was improper, as an exclusion of evidence which the law does not permit. The state thus respectfully moves the court to reverse these portions of the court's oral order. Analysis. Evidence exclusion is an extreme sanction and one not favored in the law. State v. Smith. This is so strongly a part of Georgia law that even the most well-established privileges are narrowly construed as the ascertainment of as many facts as possible leads to the truth, the discovery of which is the object of all legal investigation. Man, well, listen, this just makes me want to ask, where are the reports? But I digress. Rule 402, OCGA 24-4-402, Rule 402, provides in relevant part that, quote, all relevant evidence shall be admissible, except as limited by constitutional requirements or as otherwise provided by law or by other rules, as prescribed pursuant to constitutional or statutory authority. Applicable. You know what's a violation? When someone wants to introduce an utterance, a statement, testimony that tells the jury about the incarceration of a defendant. So, anyway, that is Rule 402. That is, Rule 402 forbids a court from excluding evidence unless constitutional or statutory authority authorizes that exclusion. Here, no constitutional or statutory authority authorizes the exclusion of the non-offending portions of Investigator Dennis's October 17th, 2024 testimony, of his future testimony, or the related exhibits. Where a purported ground for evidentiary exclusion does not come within the exceptions enumerated in Rule 402, it finds no home in any of the specific and detailed exclusionary rules included in the new code, and is unsustainable. And that's State v. Orr, as the Supreme Court of Georgia has said. The universe of specific exclusionary rules is limited by statute. First, Georgia's Rule 402 explains that otherwise relevant evidence may be excluded based on rules grounded in constitutional or statutory authority. So, all right, I guess we're just expanding on this 402 here through the Supreme Court. The evidence code's specific and detailed exclusionary rules are the obvious example. And here, this citation's going after Oregon. We've got Orr mentioned. Second, OCGA 24-1-2E grandfathers in old common law exclusionary rules, those rules which predate Georgia's current evidence code in the rare instances, if there are any, when such rules haven't been modified by statute. See Chrysler Group v. Walden. Rejecting the old party wealth evidence rule as abrogated by the new evidence code. Bolded here says that's it. That's the list. Under our evidence code, these are the only possible sources of specific exclusionary rules. See or also United States v. Lowry, 11th Circuit, explaining that the exceptions in Federal Rule 402 are an exclusive list of the sources of authority for exclusion of evidence in federal court. And then State v. Almanza. If a rule in the evidence code is materially identical to a federal rule of evidence, we look to federal case law. And this is from Stockert v. Rogers. Footnotes omitted, but then they have a footnote here, a giant footnote that says, cases in which appellate courts have rejected even well-established rules of exclusion, which were not reduced to statutory form since the adoption of Georgia's new evidence code and Rule 402, include State v. Almanza, Supra, the blanket exclusion of offender identification made during medical examinations in child sex abuse cases. This doesn't apply. This doesn't apply. When you're an offender, that's a public registration. Was abolished by the new evidence code. Chrysler Group, LLC v. Walden, Supra, common law rule excluding party wealth evidence was no longer applicable. Glenn v. State, exclusionary common law regarding identification testimony did not apply under the new evidence code. State v. Orr, statutory exclusion rules replace common law exclusionary rules, and perforce, judge-made exclusionary rules that lack even the backing of common law authority. But why wouldn't we? I mean, these things, they're couching all of this as coming in as probably cited in Stockert v. Rogers and saying, like, Rogers probably references these things. But why wouldn't they go into the specifics of how these match the situation? Where's the argument that this should apply rather than finding it distinguished? This is consistent with federal interpretations of the corresponding Federal Rule of Evidence 402, which has a prospective effect in that it precludes trial judges from future creation of new exclusionary rules of general applicability. And there's a footnote here that says, whoa, that's a word, in wrinkle read. Ian Runkle. Federal Rule of Evidence 402, the Second Revolution. Rule 402 precludes the courts from enforcing uncodified rules of evidence. While OCGA 24-6-611A, Rule 611, permits a court with control over the mode and order of witness examination, which expands on, so this footnote expands on 24-6-611A, provides the court shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to, 1, make the interrogation and presentation effective for the ascertainment of the truth, 2, avoid needless consumption of time, and 3, protect witnesses from harassment or undue harassment. Oh my God. They're going to say us saying Dennis down bad is harassment, guys. See also generally Carlson and Carlson, the commentary book that the prosecution always loves to cite. Carlson on evidence addresses cross-examination, and Rule 611C addresses leading questions, neither of which is at issue here. Further, neither provides for evidence exclusion. So that was like in the middle of a sentence up here, right? Where was footnote 3? Up here. Okay. So this footnote we just got to, I'm going to read the sentence over so we're back where we were. While Rule 611 permits a court with control over the mode and order of witness examination, Rule 611 does not authorize an order excluding evidence, and thus would not justify the order at issue here. Rule 611A mirrors Federal Rule of Evidence 611 as that rule read in 2011. Thus, Georgia courts look to federal authority for its interpretation. The state submits that federal courts of appeal are very clear. Rule 611A does not authorize the wholesale exclusion of evidence. Unlike the vast majority of the other evidence rules, Rule 611 does not purport to regulate the admissibility of evidence. Instead, the rule gives trial courts broad powers to control the mode and order of what is otherwise admissible evidence. And that's from Alan Wright and Victor James Gold from Federal Practice and Procedure. Although decisions that a court makes under Rule 611 may indirectly affect whether proof is admitted, the rule does not provide an independent ground for excluding otherwise admissible evidence. So use another witness. Use another witness. United States v. Cologne. And this was the Fifth Circuit, but it's 2005. Where a trial court ordered such an exclusion, the Fifth Circuit held that the court erred as a matter of law and therefore abused its discretion in relying on Rule 611A to preclude the government from calling the witnesses necessary to present admissible evidence. Further, the matter at hand does not involve evidence which was illegally seized under the federal or state constitutions, and does not involve a violation of other rules which have a statutory provision for exclusion, such as reciprocal discovery rules. As there is no constitutional right or statutory provision which authorizes the exclusion of Investigator Dennis's October 17th, 2024, or future testimony generally, or the exhibits related to it, the order excluding such evidence was an error and should be reversed. Conclusion, for those reasons, the state respectfully moves the court to reverse these portions of the court's oral order in which it struck the entirety of Investigator Dennis's October 17th, 2024 testimony, precluded Investigator Dennis from testifying in the future, and excluded exhibits which had been admitted through Investigator Dennis on October 17th, 2024. Respectfully submitted, Kevin Armstrong. So, there you go. There you go.